politicians become very adamant, and we refuse to take advice from the Secretariat. Because I'm just trying to understand how the drafters of this legislation would actually repeat what is already in the law. Article 179(2), whereby the county governor and the deputy governor are members of the executive committee. So why would you then again come up with that provision in this law? So I don't know whether we put a lot of pressure with the drafters and we say, you must add this, or whether we are just trying to seek some relevance, or maybe it's an issue where it was an oversight. So, Madam Speaker, I want to reiterate by saying that the intention that the Deputy Speaker, the sponsor of the bill, had is noble, is very good. I feel the pressure that deputy governors have, which is mostly monetary. Some of them, Madam Speaker, we are told they are not even given fuel by their governors. If it is an issue of being very clear that because the deputy governor deputized the governor, let us be very clear in terms of their budget, so that they do not have to depend on the governor to be given money to fuel their vehicles. Madam Speaker, we've had problems with the Assembly where we are talking about amending the PFM Act so that we can give the assemblies financial autonomy. Should we then be looking at the PFM Act and saying that, or this County Governments Act, and maybe clarifying and saying the county deputy governor, since he's a deputy of the governor, should have a clear budget, a percentage, to be able to carry out functions? That is where this problem is coming. Number two, Madam Speaker, I would also feel discouraged. If I've traversed the county, I've come in as your deputy, and you barely even consider me. You don't give me tasks to do. So I'm just sitting in my office. I'm driving a fancy car. Sometimes it runs out of fuel. If we fight, I must stoop too low so that you can be able to send some money for me for fuel. So I would cry, and I would say I need to be, I need my role to be clearly defined. So, Madam Speaker, I don't subscribe to the school of thought that feels that we should kill the bill. I think we should work with the draft of the bill to be able to make it much more constitutional, because at the current drafting of this bill, it will create two centers of powers. The county governor and the deputy governor will both have their own fights. In fact, those fights will never stop. Those fights will continue. So if we want to be able to make devolution work, the first thing that we should incorporate in this bill, which I hope that the Deputy Speaker will be able to think about it, is a dispute resolution mechanism. When they fight between the governor and the deputy governor, there is a clause that should be added on how their dispute should be resolved. We should also be able to clarify and say, because of the constitutional duty of the deputy governor, that the Assembly should define the deputy governor's budget. I support the role that every deputy governor may be assigned a docket in the county assembly, to be a CC of a particular docket. That will keep them busy, and that will also help them be able to contribute. And when they come together in the executive committee, they too can be able to contribute. The biggest challenge that I see, Madam Speaker, is that when it comes to even the executive committee, when they have those meetings, deputy governors never say anything. I want to remind those deputy governors who are out there to just take Article 179 of the Constitution and see that they are part and parcel of that executive committee. And in fact, Article 179 says the executive authority of the county is vested and exercised, is vested in and exercised by executive committee, which it is the governor the deputy governor, and the 10 CCs. So, Madam Speaker,
Senator
my views on
Olekina.
this. Oh, Mr. Speaker,
Thank
I'm
you.
glad to see you.
I wanted
You're here.
I wanted you to take note of the change of the chair.
Thank you. You know, you change so often, sometimes we don't even get to see. So, Mr. Speaker, I think it is imperative that anyone who is given a responsibility, you carry that responsibility diligently. You know, there are counties that the governor and the deputy governor work very well. My 2 cents on this is that before you go into a campaign, the two of you should have a clear, legal binding memorandum, so that you can run the county effectively and not create 2 centers of powers. Earlier, I think a couple of years ago, if it was not last year, we were asked to impeach the deputy governor of Siaya. But this House did not feel that there were merits of impeaching that deputy governor. And in fact, what was happening is there was an issue of personality differences, conflicts between the governor, James Orengo, and his deputy. So should we allow ego or egoism to be able to dictate on how governance should be exercised? My answer to that is that no, Mr. Speaker. So, Mr. Speaker, I'd like to encourage my brother, the Deputy Speaker, to take some time and personally reread every clause, because most of the clauses here that they're proposing to be amended or to be included, particularly 32, they are all a repetition, and it's a creation of nothing but confusion, as well as another center of power. Devolution should not be about power struggle. It should be about getting services to the people. Finally, Mr. Speaker, let me repeat what I just said, because it is very, very important. The intention of this bill is noble, but the drafting is where the problem arises. Let us define clearly the role of the deputy governor, and if we are not able to define it, we just do away with it. We scrap it. Once you scrap it, then we will not have these problems. If there is a change of governance, particularly if, let's say, for instance, a governor dies, then an election is held, and a new governor is elected. Because in most cases, in all the 47 counties, there is no very good relationship between the governor and the deputy governor. And in fact, the running of the county is not determined by the two. It is determined by one person. So why are we wasting time and wasting public resources? Do away with the deputy governor position, leave the governor on its own, or define the budget and clearly say you will deputize the governor on A, B, C, but not try to say you are now giving him more powers, that he can appear before the summit, represent the governor, and you are not specific. Madam Speaker, if you read the Attorney General's Act, and Mr. Speaker, I'll tell you this. In the last administration, there was a huge conflict because there's a clause in the Attorney General's Act that says the Attorney General may designate certain powers to the Solicitor General. And when the Attorney General designated those powers to the Solicitor General, trust me, the person who was now in charge of government business was no longer the Attorney General, but the Solicitor General. That was a fact. So you want to create another problem here? Thank you, Mr. Speaker.
Thank you, Senator Olekina. Senator Mariam. Senator Thangwa, the chair who preceded myself had indicated the justifications why Senator Mariam would be given the opportunity ahead of you. I take note of the fact that from the system, it's Senator Manzo who ought to have been given the opportunity to speak, but allow the chair to interchange and permit members to contribute. Senator Mariam, the floor is yours.
Thank you, Mr. Speaker, for giving me this opportunity. Mr. Speaker, first of all, I have to congratulate the Deputy Speaker for coming up with this bill to solve some issues. Mr. Speaker, everything has been highlighted, but I wanted to highlight one thing instead of repeating myself. Mr. Speaker, in a primary act, the role of the deputy governor, they were given only 5 roles. In this one, I can see almost 10 roles which has been given. Mr. Speaker, one of them, of which I have some issues about it, is on G, which is attending the county executive meeting as a member of the county executive committees. Yes, it has been highlighted in Article 179 too, as the members of the CCM. But in that article, and in the primary bill also, it is silent on the attendance of deputy governor to attend these CCM meetings. That shows that it is rather open for him either to attend or not. But this one is restricting him to attend. If he's on absent, there must be a notice. There must be also a notice to be given to the deputy governor, because currently the CCM, when they are making a meetings, the current governors, deputy governors, they are not aware. So there must be also a notice to be given. On H, from time to time appear before the county assembly to respond to the question related regarding the implementation of the county development projects by the county executive committee. Mr. Speaker, I totally disagree with this one because the county, when I take, let me take you to, on that one, Mr. Speaker, the chair of the CCM is the governor. If he is governor, now if you are giving a priority to the county assembly, he appear to the county assembly anytime, from time to time. That is contrary to the appointment where they are appointed as the county executive members, because who appoints him as a county executive member is the governor. So the overall chair is the CEO of the county government. The CEO of county government is responsible to answer all questions to the county assembly, not to him. Maybe he can appear to the county assembly on responding to the docket he has been given under the county executive committee members. Because when we visited some counties, we realized that CCM of health, most of them is deputy governor. Now, when the issue of county issue of the health issues to be raised, he can appear as a CCM, not as a county deputy governor. So they have to specify at what time he can appear on the county assembly to respond to a question to who. On the other one is on the issue of assisting governors in implementation of the county budgets. In this one, it is a blanket clause. It has to be specific to assisting governors in implementation of the county budget on which role he has been given as CCM. Because if he or she has not been given a CCM, he cannot take that opportunity of implementation of the budgets and monitoring of expenditure. So this one must be specifically to the role he or she has been given in the county CCM docket. As per the G, serve as executive liaison office with the county assembly for the purpose of facilitating and fostering the positive relationship between the county. Mr. Speaker, this one is overruled because he is not the CEO of the county executive. So the person who is county executive is a governor who contrary to the respond to the county assembly and also make relationship with county assembly. But if you give to the county deputy governor, it is more of colliding of the county governor and the deputy governor. And what is happening, even because they are fighting on that, this role will come up and it brings the conflict of interest between the two. Mr. Speaker, with those, because others has been highlighted, I don't want to repeat myself, but it needs amendment on these issues I have highlighted. Mr. Speaker, I support the bill with the amendment. Thank you.
Senator Manzo.
Thank you, Mr. Speaker. Mr. Speaker, you know, I want to go back to the Constitution and, you know, the county executive, how the county executive is formed. This is under Article 179(4). The county governor and the deputy county governor are chief executive and deputy chief executive of the county, respectively. Subsection 5, when the county governor is absent, the deputy governor shall act as the county governor. And then, you know, also under Article 180, subsection 5, each candidate for election as a county governor shall nominate a person who is qualified for nomination for election as county governor as a candidate for deputy governor. Those are the provisions in the Constitution. And from the proposal which has been proposed by Senator Gathuri, Senator for Meru, who I have a lot of respect for, is seeking to delete the order section 32, which has 5 subsections, and bring in a new section 32, which has got, you know, quite a number of, up to J, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, which has added 7 more functions. Mr. Speaker, if this bill had come to the Committee of Justice, I believe it would be looking different. Unfortunately, it went to devolution. Ordinarily, I think this sort of law should have come to the Committee of JLAC. Mr. Speaker, you will be aware that the idea is very good and very noble, and I think it should not be lost. We are aware as the Senate that quite a number of governors and deputy governors have had issues. But how to regulate those issues and how to deal with them, first of all, you need to look at the relationship. In the event the governor is no longer governor, the deputy governor is automatically sworn to office. Both of them have same qualifications in terms of qualification to be elected as governor. And therefore, I am looking at a situation whereby what is the idea? What was in the original idea of the original Section 32? We have seen, like in the case of Machakos, when Mutua was governor, he immediately fought with his deputy and even brought him here for impeachment. The Senate refused to impeach, kept him without an office, without a vehicle, without employees, for as long as they were serving together, and finally he exited. His next deputy governor was appointed the CEC in charge of finance. And then, you know, there are many other examples in the country where we have seen deputy governors be brought here for impeachment, then it works or it doesn't work, and the two have to go and coexist. And what tends to happen when the governor differs with the deputy, then it seems to be a problem. And in a lot of cases, like in the case of Honorable Savula and his governor, you know, both of them are shareholders of their government. I would say equal shareholders. Each person contributed to the existence of the other. You know, Honorable Savula, having been a member of parliament and having been a journalist, and is very vast with many things. I believe the two of them gel very well and help each other very well and are able to share power. But it was an idea for governor and deputy to share power equally. I don't think so, although such arrangements can be done. And even that has been the situation in the national government in Kenya. Since devolution came, and since we have a presidential system, each election, the election of President Uhuru and William Ruto were like 50-50 shareholders of their government. Similarly, at the first round, and even a second round, and even currently, the election of William Ruto as president and the second deputy governor of the republic, it was a 50-50 arrangement. If anything, Rigathi Gachagua had brought, you know, more numbers than the other. And similarly with the county governments, there's nothing to call out of order. I know you don't like the second deputy president, but even when you, Cheragai, when you become, there's no point of order.
Senator Manso, let me allow Senator Cheragai to raise his point of order. Senator Medhu and Senator Thangwa, the chair is one. And I have allowed Senator Cheragai to raise his point of order. Senator Cheragai, proceed. It is the chair to determine whether it is a point of order or otherwise not. Proceed, Senator Cheragai.
I proceed.
Proceed.
With the class. Mr. Speaker, I raise understanding order 105 on responsibility for a statement of fact. But Mr. Speaker, straight to the point, have you heard my brother, senior counsel Senator Manzo, not senior colleague, by alluding and stating that the arrangement between President William Ruto and the impeached Deputy President Rigathi Gachagua was 50-50. Can he table the evidence to show that there was a 50-50 arrangement, Mr. Speaker, sir? As per the standing order 105. I yield back the mic, Mr. Speaker, sir.
Senator Manzo, you've heard the point of order. Are you able to table any document to that effect? If not, you can substantiate it otherwise.
Mr. Speaker, I can't table, but it's a matter of fact. I do withdraw that, but the way they shared government was a matter of fact. The point I was trying to drive in, Mr. Speaker, is that when there is a president and deputy, or when there is a governor and deputy,
Senator
sometimes
Kinyua.
they are political.
Senator Manzo, take your seat again. What's the point of order, Senator Kinyua?
Mr. Speaker, I'm raising on a point of order 105, statement of fact. Mr. Speaker, it is so obvious after it was, I want to agree with Senator Maanzo that it was 50-50. I was a member of UDA. And Mr. Speaker, I want to state that after they disagreed, after they disagreed, Mr. Speaker, the Deputy President, Rigathi Gachagua, and the President, that is what caused what happened in all Kalau, Mr. Speaker. And you can see exactly
what is your point of order, Senator
disagreement,
Kinyua?
Mr. Speaker.
What is your point of order?
I'm confirming what...
Take your seat, Senator Kinyua.
I'm confirming what Manzo is saying.
Senator
It was
Kinyua.
50-50, Mr. Speaker.
Take your seat, Senator Kinyua. Senator Manzo, proceed.
Yes. Thank you,
You're
Mr.
out
Speaker.
of order,
I'm
Senator
just saying,
Kinyua.
Mr. Speaker, ordinarily in the elections, and I'm sure some of us who will want to run for governor one day will find themselves in that reality. Your deputy, you may have to do a political agreement. And I think this is what drives to the problem after election, because ordinarily under the law, the governor is supposed to take full charge of the government, and the deputy is a principal assistant. And I think this is what our good Senator Kathuri was trying to, and the Deputy Speaker was trying to address. We know they have been concerned. I wish you could see the public participation report and how different deputy governors responded. I have heard these cries myself. I have helped settle situations where a governor and a deputy have differed, and the county is suffering. The development is not going as usual. The political situation has become hostile. And eventually, Mr. Speaker, we must find a solution to this. And having got to find a solution, I think what we should happen, what we should do, Mr. Speaker, at the third reading, we need to redraft this amendment bill to suit the situation. And that's why public participation is very important in any legislation, and especially the report, and the adoption of the feedback from the people. This House has already now given feedback, and luckily we've got very experienced people in this House. Senator Sangwa and Senator Methu have had an opportunity to serve in counties and understand this relationship very well. They have contributed very well, and Senator Methu has contributed very well, and I think Sangwa will even do better after me. And I've also heard Senator Mariam, who has a lot of experience from the county where she comes from. So if you listen and follow keenly to people who are in this House and have worked in county governments before, and they have done so in senior positions, they are able, or representatives. I wish Senator Murago was here, who was also an MCA in Kirinyaga County, and now wants to become governor there, and I'm sure he will be a very good governor. It means that we have to draw that experience, and then using that experience, and especially from Senator Methu and Senator Sangwa, redraft this and come up with something which gives a solution to what we are trying to form a problem. Although Senator Methu has put it very well, it's like trying to cure diarrhea. By blocking the exit, you increase the problems, and the person is likely to die. So we are likely, we are likely. I'm just quoting. Yes, I'm just quoting, but I'm just saying the problem is likely to become more. And therefore, we don't want to increase the problems between the governor and the county governor. We, as a Senate, who believe in devolution, want to solve this problem, want to make sure that counties go on well. But I want to believe, if from my Makueni experience, now,
Senator Cherargei, allow Senator Manzo to conclude on this. Allow Senator
I'm
Manzo
just about to wind up, and I'm coming to the positive side of things. I want to say that in Kenya, there have been many counties. No.
Senator Manzo, you are addressing the chair, you are not addressing Senator Cherargei.
Yes. I'm addressing the nation, and I've stated facts as in case I was...
Senator Manzo.
Yes.
You are on the floor.
Yes.
You're not supposed to talk to your colleague, Senator. Proceed.
But the interruptions are
Unless
so
you are
much. I don't know whether Senator Cherargei wants to run this Senate alone. Then you should be talking alone if you cannot allow others to think.
Senator Manzo.
Chair, I want to conclude and say there are many examples of good working relationships in many counties in the country. One of it is Makueni. You know that the governor of Makueni and the deputy governor of Makueni. In Makueni practice, if the governor is a male, then the deputy is female. If in future, if a governor will be female, the deputy will be male to balance gender parity. And what has been happening is like the current situation, we have a deputy governor who is a former county commissioner and with long experience in government. And she's come out very hardy in terms of stabilizing the government and making sure technically the government is well run. In fact, when we have the national days, they are much better than the previous one. The previous one, the national days, you would find the governor and the county commissioner and a few people. But now it's a full-fledged, occasion in Makueni, and it's a good example of where governor and deputy governor can work together. I believe, even without this regulation, many governors and many deputy governors can work together. We cannot really regulate or enact laws to regulate a relationship. It has to be created. People must be willing. There must be respect between the governor and the deputy, and there must be space and allow the deputy to deputize the governor. If that happens, I'm sure there will be no problems. There will be no need for this regulation. But unfortunately, in quite a number of counties, there have been problems. We have seen a governor bringing a deputy here for impeachment. Some have successfully been impeached, others not. And therefore, there is a need to make this law better, relook at it, a third reading, and make sure that it serves the country. I thank you, Mr. Speaker. I support.
Senator Thangwa.
Thank you very much, Mr. Speaker. As I also contribute to this important bill. And this bill is seeking to give powers to the deputy governors, Mr. Speaker. And Mr. Speaker, I happen to be a member of the Devolution Committee. And in the Devolution Committee, we went through this bill. And we gave our observations. And of course, we also gave our recommendations, Mr. Speaker. But Mr. Speaker, before probably I say whether I'm supporting or opposing this bill, I just wanted to it to sink in your mind. Can you imagine having a deputy governor like Senator Cherargei? So now with that in your mind, Mr. Speaker, you realize you do not need this kind of law, Mr. Speaker. Because, Mr. Speaker, the law is very clear.
Senator Thangwa, I do not want to allow Senator Cherargei to interrupt you. I do not find anything offensive with referring Senator Cherargei in any other manner unspecific as you have done.
Yeah.
But watch the speech that you proceeded.
Thank you.
Content, especially in reference to your colleague, Senator, or any other person who is not in this House.
Thank you very much, Mr. Speaker. I'm well guided. I'm well guided. Now, Mr. Speaker, I want to give you a bit of the genesis of this bill, because I do understand, because it came to the Committee of Devolution many months ago. This bill was supposed to cure what was happening in Meru County then, Mr. Speaker. If you remember very well, there were issues of governor and the deputy. The deputy governor, the governor was impeached about 4 times and returned to the office. And they thought they would bring a bill that would create a co-governor. And this is the bill, Mr. Speaker. Mr. Speaker, we cannot cure mistrust with the law. Just like Senator Medhu once told me, and I believe probably he said it on the floor of this House, you cannot force people, and especially politicians, to love each other. So this bill, Mr. Speaker, and I like using analogies, is like the best man of a certain wedding requesting some roles from the bridegroom, Mr. Speaker. Mr. Speaker, when you ask to be a deputy governor, your work is only one. You are a governor designate, just in case the governor dies or the governor is impeached, period. And if you feel you're good to be a governor, run as a governor, Mr. Speaker. The Constitution, and that's why I want to declare this law, Mr. Speaker, this law is seeking to amend the Constitution through the back door, Mr. Speaker. If you read the Constitution, Article 179, 2A, it says the County Executive Committee consists of the county governor and the deputy county governor. Already the Constitution is saying. So why do we say it in this law? Why are we saying this law that he should be attending these cabinet meetings, he should be given enough time, prior time? You're actually telling the governor, be writing to the deputy to invite him to the meeting. They have their own mechanism. Mr. Speaker, if you read the same article, 179(5), when the county governor is absent, the deputy county governor shall act as the county governor. That is the only role the Constitution gives the deputy governor when the governor is absent. If the governor is present, just go home and rest, Mr. Speaker. This is the Constitution. Why are we amending the constitution by telling the governor, the deputy governor, to be a co-governor? So I do understand what they were trying to cure then. And since it was cured, and the person whose the law was supposed to help is already a governor, can we just withdraw this bill and say, if you want to be a governor, just run as a governor, Mr. Speaker? Mr. Speaker, the law is already available. This law is in the County Government Act. If you read the law, section 32 of the County Government Act, which is being amended by this law, Mr. Speaker, and you can see it has been amended by so many clauses, from A all the way to, Mr. Speaker, J. This law removes one of the fundamental sections that the law created when they got to know that the deputy governor is not a co-governor. He only acts when the governor is away. So if the governor is available, then he can only do what he has been assigned by the governor himself. Mr. Speaker, let me tell you what they remove with this law. Section 32(4) of the County Government Act says, when acting, remember the law says he should act when the governor is absent. When acting in office, as contemplated in Article 179(5), the one I've just read of the Constitution, the deputy governor shall not exercise any powers of the governor to nominate, appoint, or dismiss that are assigned to the governor under the Constitution or other written law. This law has deleted that clause. What does that tell you? They want the deputy governor to start dismissing, the deputy governor to start employing. So we are creating two centers of power, trying to cure the problem that was in Meru that probably was cured when they already impeached the governor, but I don't believe it was cured. Mr. Speaker, if you read that section again, 32(5), the governor shall not delegate to the deputy governor or any of the functions referred to in subsection 4. So the law is even telling the governor, you cannot even delegate that. Now here we are as a Senate, we are now creating two centers of power, trying to tell the deputy governor that he can even manage budgets and finances. That is the work of the county treasury. You know, if you want to be a county treasury, nothing stops you from talking to your governor, and then the governor can make you a CEC for treasury. Nothing stops. I am a former MCA, and Senator Maanzo has told us that we have a lot of experience. I believe in this house, nobody has more experience when it comes to devolution than myself. I've been an MCA, I've been a CEC, executive in the cabinet, and now here I'm as a senator, Mr. Speaker. So what I'm trying to say today is that we should not try to legislate relationship. If they're working together, work together. If they're not working together, somebody can resign. You are not supposed to be in an office if probably you are not working. And Senator Ledama, although I don't agree with him in most cases, he has said, actually the best thing is to scrap this seat of the county deputy governor. And I support, if we cannot cure the relationship, let's scrap that, and that is the amendment of the Constitution. Let's remove this seat so that if you impeach a governor, let people be given a new mandate to go and elect a different governor. Actually, so many impeachments that have come here, and you will agree with me, Mr. Speaker, they have been induced by deputy speakers. By deputy governors. So actually the problem is them, because they want the governor to go so that they can take the seat. So, Mr. Speaker, as I conclude, I would want to say the problem is more political than legal, Mr. Speaker. And since we cannot cure political problems through the law, let those who want to run as deputy governor know that the boss is the governor. The law gives the governor more powers that he can delegate some if he may. If you remember that gentleman who said, it says shall or may. This one says may, not shall, Mr. Speaker. So it depends on, nothing stops him today to appear before the county assembly. Actually, the county assembly can summon anyone. I think that is Article 185 of the Constitution, if the senior counsel can help me, Senator Ojenda. But that is what the law says, that anybody can appear. Nobody stops them. What these deputy governors are trying to do, they are trying to get power so that there can be two powers, centers of power, and they try to, because they are unable to impeach the governors, now then there can be push and pull between these two people. Now, who will we be summoning to appear before the Senate as committees? Will we be inviting the deputy, or will we be inviting the governor? Remember, Mr. Speaker, we have had problem with the county assemblies, whereby we have had two speakers, two county clerks, and even two assemblies. Can you imagine what this law would do? We will be dealing with these issues where a certain deputy governor has already taken the whole county headquarters to a different place. Now we have two governors who are dealing with the county. So I oppose this law and implore the senator of Meru. The problem you tried to cure was cured. So we withdraw this bill, and we have only 1 year to the election. Then people can appoint deputy governors who are willing to work together. If you don't work together, and I heard Senator for Migori, Senator Eddy, he was talking about that removing a governor from the Kuria side is removing the whole community. And you know, Mr. Speaker, that's the exactly thing that we were trying to say here when the deputy president of this republic was being removed. Removing the deputy president is removing Murima, is removing the whole community. So, Mr. Speaker, because I do understand this was supposed to cure something very different, and it has been cured. I raise my case and oppose this bill, which has been seconded by Senator Cherargei, and I will tell you, you will be all callowed, all of you.
Senator Tom Ojenda.
Thank you, Mr. Speaker. Mr. Speaker, I should speak from the dispatch. Mr. Speaker, I with a very heavy heart, I agree with Senator Thangwa on a number of questions. The first question, Mr. Speaker, is that a close reading of Article 179 that confers executive power to the CEO of the county, who is the governor, and if you read in there, deputy CEO, clearly shows that the governor, while holding the power in the county to appoint and to execute all that has to be done in the county, has the mandate to delegate executive power to the deputy governor. And Mr. Speaker, what this bill does is to try to designate or to direct the governor to share executive power with the deputy governor and the committee in the county, the CECs, as properly designated by the Constitution. Mr. Speaker, this is an amendment, is an unconstitutional amendment to the Constitution. The intention of this bill, Mr. Speaker, is to undermine the very provisions that the Constitution clearly provides for. And the proper way, Mr. Speaker, to elevate or to otherwise deal with the power of deputy governors, Mr. Speaker, is to bring an amendment to the Constitution. Short of that amendment, Mr. Speaker, it is impossible through a bill that is brought before Senate to kind of recraft, Mr. Speaker, the Constitution in a manner that is unconstitutionally trying to deviate from constitutional provisions. Mr. Speaker, this bill, and again let me also agree with Senator Thang on this bill was brought against the backdrop of the impeachment of the governor for Meru, whose action is still in court. And I must say that at some point she was my client. And the governor was since replaced with the deputy governor, who is the substantive governor of Meru County. Though I understand that governor has suddenly become very popular after her impeachment. But Mr. Speaker, the point here is that this bill may have served its purpose and should have been dropped at this point, because it was tailor-made for purposes of Meru County and did not succeed at the time. Mr. Speaker, we have examples of counties where deputy governors and governors sit in well and work together for the people. Let me give you an example, Mr. Speaker, of my own county, Kisumu, where the deputy governor, Dr. Willie, is sitting pretty. He's a sitting pretty duck. He's out there. He only does assignments given to him by the governor. Other times, he's out there, he's idle. He does not perform any duty unless Governor Nyong'o assigns him that role. So that shows you that deputy governors who are not overzealous, who are not too keen to carve their own space, work well with governors who are in office. A strong deputy governor and a strong governor can hardly survive in the same space. If you look at the example of Makueni, Honorable Speaker, you find that Makueni is a shining example of a perfect coexistence of the governor and deputy governor. Look at Kakamega, but where, Mr. Speaker, in Siaya, for instance, you had Deputy Governor Oduol brought to Senate for impeachment by Governor Orengo, because the deputy governor was trying to carve out gubernatorial powers from the governor, which he cannot enjoy unless Article 179 is amended. Let us not, Mr. Speaker, cleverly take away powers of the CEO of the county through a bill or through legislation and purport to direct through the back door a governor to give powers to the deputy governor, including powers, for instance, as the bill designates, for a governor to appoint a deputy governor as a CC. That is shared power. You cannot sneak and share power of a CEO from the back door. Let it be done through the front door, Mr. Speaker, as the law mandates. Mr. Speaker, I oppose this bill. It is utterly unconstitutional and should collapse on its backside and die. Thank you, Mr. Speaker.
Thank you, Senator Professor Tom Ojenda. Senator Kinyua.
Asante Bwana Spika kwa kunipa fursa hii. Kwanza kabisa Bwana Spika, nataka kumpongeza Seneta wa Meru, naibu wa Spika, kwa mswada huu ambao ameuleta katika bunge hili. Bwana Spika, amejaribu kutuliza mgogoro ulioko kati ya magavana na manaibu wao. Lakini Bwana Spika, kujaribu kutuliza mgogoro huu, kwanza kabisa mimi na itakumbukwa baada ya mimi kwa seneti iliyopita nilikuwa mwenyekiti wa kamati ya ugatuzi. Bwana Spika, naibu wa gavana wa Pokot, miaka 4 ilikwisha bila yeye